Good afternoon, and welcome to today's installment of the Law Library's Foreign and Comparative Law series. I'm Ellen Hofferberg, and today Kelly Buchanan, hi Kelly, and I will be discussing the land and natural resource rights of Indigenous people in New Zealand and Sweden, our countries of origin. Before we begin, we want to acknowledge the ongoing safety situation near the Library of Congress buildings on Capitol Hill in Washington, D.C. Everyone involved in this webinar is working off-site today, and we continue to serve Congress and the public despite the situation. Around this time last year, we discussed the different approaches in New Zealand and Sweden with respect to tackling the coronavirus pandemic, and found the contrast between these small, developed democratic countries in different parts of the world very interesting. We hope to give some similar insights in our discussions today, noting, of course, that the area of Indigenous rights is a huge topic with multiple complexities in terms of culture and history, and detailed complex laws, court decisions, and government policies. We'll be providing a broad overview of these in our discussions, along with resources for those that want to delve more deeply into the subject. We'll begin by providing a quick summary of the historical context with respect to Maori people of New Zealand and the Sami people of Sweden, particularly the impact of colonization and contact with non-Indigenous people and entities. We'll also provide information regarding the demographics of Indigenous people in the two countries, as well as on their current legal status and political representation. Then we'll look at the history, legislation, court cases, and government policies regarding, first, the land rights, and secondly, rights related to natural resources. Finally, we'll list some Law Library of Congress online resources related to Indigenous rights in New Zealand and in the Nordic countries before answering any questions. Please use the Q&A function to submit your question during the presentation. Thank you.
Good afternoon, everyone. So looking first at the history of New Zealand. The Māori people are Polynesian, with groups arriving as a result of deliberate voyages, possibly from the late 1200s. In terms of traditional structures and groupings, there were large and smaller divisions of people with some differences between them in terms of practices and dialects. Terms that you will frequently see in relation to land and resource rights are iwi, referring to a larger tribal grouping based on common ancestry, and hapu, referring to sub-tribes with historical connections to smaller areas of land. There were established settlements and even fortifications. Māori society was organised based on core beliefs and principles, or kaupapa, from which various rules, behaviours, practices and protocols were derived, referred to as tikanga, with particular aspects or practices now acknowledged by the courts as being customary law. European settlement began relatively slowly in the late 18th and 19th centuries. Before 1840, arrivals could be counted in the hundreds, but by the 1860s, this increased to tens of thousands. Meanwhile, the Māori population decreased from about 100 to 200,000 in 1800 to 70 to 90,000 in 1840, particularly as a result of intertribal wars over that period and due to introduced diseases. The settler population in 1840 was only around 2,000. But starting in the 1830s, there was concern in Britain and among missionaries in New Zealand about unregulated colonisation and its impact on Māori, including as a result of fraudulent land transactions and unruly behaviour by the settlers. And there was, of course, also interest in securing commercial interests as well as competition with the French. Various actions led to the signings of the Treaty of Waitangi in February 1840, with about 40 Māori chiefs signing the Māori version on February 6th, and a further 540 signing the treaty by September that year. It was on the basis of this treaty that the British claimed sovereignty and established a government in New Zealand. As explained by the official New Zealand history website, the document has 3 articles. In the English version, Māori cede the sovereignty of New Zealand to Britain. Māori give the Crown an exclusive right to buy lands they wish to sell, and in return are guaranteed full rights of ownership of their lands, forests, fisheries, and other possessions. And Māori are given the rights and privileges of British subjects. The treaty in Māori was deemed to convey the meaning of the English version, but there are important differences. Most significantly, the word sovereignty was translated as kawanatanga, or governance, and some Māori believed that they were giving up government over their lands, but retaining the right to manage their own affairs. The English version guaranteed undisturbed possession of all their properties, but the Māori version guaranteed tino rangatiratanga, or full authority over taonga, treasures which may be intangible. Following the signing of the treaty, there was conflict between different Māori groups in the North Island and the Crown in relation to land, referred to collectively as the New Zealand Wars, which lasted into the 1870s. The colonial government's policy priorities can be seen to involve assimilation of the Māori population into European society, culture, and language, as well as obtaining land for settlers by various means, which I'll talk more about soon. There was pushback from Māori throughout the 19th and 20th centuries, with the Māori protest movement particularly gathering steam from the 1970s. The 1970s and especially the 1980s is also seen as the beginning of a Māori renaissance in terms of language and culture. There were also important legal and policy developments, including the establishment of the Waitangi Tribunal as a permanent commission of inquiry to hear and issue non-binding reports and findings with respect to breaches of the treaty. Then, from the early 1990s, the government commenced and developed processes for settling claims by Māori groups, including with respect to land and resource rights. This period also saw the development through legislation in the courts of references to taking into account or upholding the principles of the treaty. These have been formulated in different terms and contexts, but can largely be seen to include the principles of partnership, informed decision-making, active protection, redress, and self-determination.
Unlike the Maori groups in New Zealand, the Sami indigenous to Sápmi, an area that extends across the northern parts of Norway, Sweden, Finland, and Russia, created no fortification or permanent settlements on the land they used. Instead, Sami group used vast areas of land to provide grazing grounds for reindeer, to hunt, and to fish. In Sweden, these areas, used by different Sami groups, make up almost half of Sweden's landmass, encompassing roughly all land north of the city of Östersund, although the southernmost point is Idre. The combined area is sparsely populated and only home to about 10% of the Swedish population. Historically, the Sami people have been viewed as nomadic by the Swedish state representatives because they used a large area to herd reindeer in and moved between winter and summer pastures. But there are also groups of Sami known as forest Sami or skogssame that were and are more stationary in their reindeer herding with fewer reindeer and smaller, more controlled areas. In fact, historically, Swedish law distinguished between fjällapp, skogslapp, and nomadlapp, meaning mountain, forest, and nomadic Sami groups. The term lapp is no longer used and is derogatory, and I will use Sami throughout this webinar unless I am describing a legal construct that uses that name. Exactly when the Sami groups first began to use the land in Sápmi hasn't been determined, but the oldest document preserved to present day that likely describes the Sami population is a reference to ski-faring Finni from about 300 AD in Germania by Cornelius Tacitus. The document outlining relations between Sami group and Swedish state authorities date back to the 1500s, when Swedish kings collected tax from Sami persons living in the northern parts of what we now call Sweden. Except for the taxes that appear to have been initially personal to the head of household, the Sami led a rather uninterrupted life with little interference from the Swedish crown, and any permanent non-Sami presence was basically non-existent at that time. Although there have been agreements between different groups on where they kept their reindeer, there are no written sources for these agreements that were likely based on customary use. At that time, the Swedish crown had little interest in the northern areas, other than to tax the Sami, which was as much a way to maintain or make territorial claims over the area compared to other nations as it was to collect money. Initially, the area belonged to each Sami group was not mapped, but the state became more interested in defining the area in the 1600s. For example, a 1611 map of Laponia by Andreas Berreus includes several Sami lands, including Tingevara, Kautokeino, etc. Similarly, in 1671, Anders Gädda created a map over the northern areas of Lappmark, mapping 37 Lappskatteland or Lapp tax areas, and finding that the vast land could tolerate increased use by other groups than the Sami. Shortly thereafter, in 1673, King Carl XI issued the first Lappmarksplakat and called for farmers to settle the northern parts of the country in order to produce more taxable income for the state. Migrant farmers to populate the north with promises of 15 years of tax-exempt status and a promise not to be subject to military conscription. This migration of farmers northward now created an interest from the king in regulating or at least controlling the who, what, where of Sami reindeer movements. Similarly, the Sami cross-country or cross-border movements had not been an issue in the 15 and 1600s. However, following the Strömstad Border Treaty of 1751, which created a new indefinite border between Norway, that meaning Denmark, and Sweden, which at that time included Finland, The Lap Codicillan was an amendment to that border treaty and later seen as a Sami Magna Carta because of the rights the Sami listed in it, expressly recognized the right of Sami to travel across the border between Sweden and Norway, based on a time immemorial right, irrespective of the citizenship of the individual Sami. However, the codicil also limited the right of the Sami, who no longer could hold land in both countries. Thus, each Sami family had to make a decision to be a Swedish or Norwegian Lapp. Naturally, the border soon became a source of conflict. Fluctuation in the size of the reindeer populations, redistricting of Sami areas to accommodate non-Sami population interest, and Norwegian government hostility towards the Swedish and Finnish Sami all created scarcity of land and resources, motivating forced migration of Sami groups within Sweden starting in the late 1800s until the 1930s. The forced migration further strained Swedish relationship between the Sami groups, as Sami that used large areas to graze their reindeer moved south, where the Sami used smaller, more controlled areas to herd their reindeer. The state had failed to realize that not all Sami practices were the same. Around this time, there was also a large push to assimilate any Sami person who was not a successful reindeer herding Sami. A government policy that Lapp ska vara Lapp, or Sami should remain Sami, developed. The churches that were built in Sápmi in the late 1600s now became instrumental in educating Sami children, often away from their parents and culture. Issues of language rights, cultural protection, intellectual property rights to Sami duodji, and the return of human remains from museum will not be addressed in this webinar today, nor will the policy conflict of protection of wild animals such as the wolf, predatory against the reindeer. But I wanted to mention here that these conflicts exist and continue to mark Sami-Swedish state relations. Similarly, the Alta conflict in Norway is outside the scope of this presentation, but it illustrates how a Sami group quite recently was negatively affected because of a resource use in the form of water power needs of the Norwegian government, resulting in the largest conflict in recent history in Norway. Land use conflicts also mark the Sami-Swedish government relations, as mining, creation of windmill parks, and other government land use policies impact the land that Sami used to herd reindeer. As I will get back to later, the solution to that conflict may lie in an effort to create a truth commission to recognize and right past wrongs against the Sami, but also in court precedents, which are increasingly defining what the Sami people's time immemorial rights entail.
In terms of current demographics and statistics, you can see that Māori now make up more than 16% of the population in New Zealand, where there is a total of about 5 million people. In comparison, around 70% of the population identify as being of European descent. The overrepresentation of Māori in the context of negative social and economic statistics and concerns about discrimination against Māori have been noted at various times by international bodies. This includes lower life expectancy, higher rates of imprisonment, and lower educational achievement compared to the overall population.
Unlike New Zealand, Sweden has no exact figures on how large the Sami population in Sweden is. The last official count was a lappräkning, Sami count, in 1945, and the current count estimate is at about 20,000 out of 10 million. About 9,000 individuals are registered as voters in the Sami election electoral rolls. However, voter registration procedures are cumbersome, and the rolls are not believed to include all descendants of the Sami people. Sweden keeps few statistics with respect to the Sami overall, as it does not provide ethnic-specific statistics. However, neighboring Norway has conducted research into its Sami population and found that the Sami as a group have a 1.6 year shorter life expectancy than other Norwegians. Other studies have also found that there is a higher rate of suicide among reindeer herders in Sweden relative to the Swedish population at large. There appears to be no overrepresentation in the justice system or the welfare system for Sami, and the educational level is not measured, although the education is only mandatory at grades K through 9 in Sweden.
Māori representation in New Zealand's parliament is guaranteed in the Electoral Act through the designation of dedicated seats which represent Māori electoral divisions, in which those registered on the Māori electoral roll can vote. These seats were first established in 1867. The different parties represented in parliament include members from these seats, as well as other Māori list and general electorate members. An ongoing issue in the country relates to Māori representation on local authorities, where the majority of decision-making occurs with respect to land and resource use. More broadly, the treaty is now seen as the country's founding document and as being part of its constitutional arrangements, with New Zealand not having a single written constitution, but rather various written and unwritten constitutional documents and rules. Māori, or more specifically particular groups in different parts of the country, have the status of a treaty partner and as tangata whenua, or people of the land, also see reference to mana whenua. There are multiple different legal and governance entities currently in use by Māori to manage relationships and assets, including those resulting from treaty settlements. At the international level, New Zealand originally voted against the adoption of the United Nations Declaration on the Rights of Indigenous Peoples in 2007, along with Canada, Australia, and the United States. The government at the time was concerned that it was incompatible with New Zealand's constitutional and legal arrangements and treaty settlement policy, and worried that it would create a veto right over legislation. However, a new government subsequently announced its support for the declaration in April 2010, stressing its non-binding and aspirational nature. The Human Rights Commission in New Zealand stated that the declaration holds considerable moral authority and contains principles that are consistent with those in the treaty, New Zealand's founding constitutional document. This means that government decisions and policies should take the principles of the declaration into consideration alongside the treaty. In the past couple of years, New Zealand has indicated that it aims to be the first country in the world to implement the declaration and is currently developing a national implementation plan.
Unlike New Zealand, the Sami groups did not collectively sign a treaty with the Swedish crown, and the relationship between the Sami and the state has remained largely undefined. Sweden has been reluctant to acknowledge the status of the Sami people as indigenous and the rights connected with them. For example, Sweden has not ratified the Indigenous and Tribal Convention of 1989, known as ILO 169. And although it did sign the United Nations Declaration of the Rights of Indigenous People, UNDRIP, in 2007, it did so with several comments regarding its interpretation of the articles, including those pertaining to land rights. Yet the special status of the Sami people is referred to in the Swedish Constitution, where in Chapter 1, Article 2, it states that the Sami peoples and ethnic, linguistic, and religious minorities' possibilities to maintain and develop its own cultural community life should be promoted. Thus, the Constitution does not designate it as indigenous, but recognize it as a folkgrupp, a people. The paragraph was added in 2010. Note, however, that it is referred to as gold paragraph and does not confer a tangible specific right for the Sami to take to court. Note here also that the ILO 169 has been signed and ratified by Norway, and that the Sami people of Norway is legally recognized as an indigenous group there. Unlike the Maori in New Zealand, the Sami have no designated seats in parliament, and there are currently no Sami members in the Swedish parliament. Notably, the Constitution makes no reference to the right to self-government of the Sami. In fact, Sametinget, which literally means Sami parliament, is, despite its name, a government agency and not a traditional parliament. It monitors issues relating to Sami culture in Sweden and is responsible for reindeer husbandry issues, including designating Samebyar and its territories and boundaries. The Sami parliament held an election this year with 9,226 eligible voters. The voting right is based on a person's designation as Sami in the Sami Parliament Act. That is, whether the person speaks Sami in his or her home, or if a grandfather or grandmother did, and not the person's status as a reindeer herder. However, reindeer herding rights, or any of the connected rights such as fishing or hunting that belong to the Sami, is not based on the voter registration or use of Sami language, but whether a person is a member of a Sameby, which means literally Sami village, but it is also described as a Sami administrative district. Simplified for reasons of brevity here, the Sameby is a legal and financial association that has a communal right to herd reindeer in a specific area. For instance, members of Girja Sameby have a right to herd reindeer in the Girja Sameby area. Acquiring membership in a specific group may not always be easy, however, and speaking a Sami language is not sufficient. Persons who are not members of a Sameby typically don't have any rights to herd reindeer or exercise other rights for hunting on the basis of being Sami. This reflects how, in Swedish law, Sami interests and Sami rights have historically primarily been synonymous with reindeer husbandry rights. In fact, the Reindeer Husbandry Act states in Article 1, he or she who is a Sami is of Samic heritage, i.e. that is a Sami, may in accordance with the provisions of this law use land and water for the support or upkeep or sustenance of herself or her reindeer. The right in accordance with this first section, the reindeer husbandry right, appertain to the Sami people and is based on the principle of time immemorial. The reindeer husbandry right may be exercised by a member of a Sami village. Thus, while the reindeer husbandry is a time immemorial right of the Sami people at large, it is nevertheless limited, if you read the black letter law in the provision, to persons who are members of a Sami village, reflecting the view that only a reindeer herding Sami is a true Sami, which has prevailed in Swedish government policy since the taxation of reindeer households in the 1600s. Compare this to the right of the constitution of the Sami people to maintain and develop its cultural and community life found in Chapter 1, Article 2. It makes no mention of reindeer herding. However, the special status of reindeer herders and the Sami monopoly on reindeer husbandry is explicitly stated in the chapter on fundamental freedoms, Chapter 2, Article 17 of the Constitution. Thus, the right to reindeer herding is stronger than the right to other cultural elements of the Sami culture.
Now turning to the situation with respect to land rights. As I noted previously, the Treaty of Waitangi granted the Crown the exclusive right to purchase land for Māori. By 1865, nearly all of the South Island and about a fifth of the land in the North Island was in Crown or private ownership, with the New Zealand History website explaining that Crown agents developed some dubious practices to persuade Māori to sell, and they could offer whatever the government was prepared to pay rather than a market rate. The government was the arbiter as well as the defendant when Māori complained. The New Zealand Wars resulted in further alienation of Māori land in the North Island through the use of confiscation or raupatu, authorised by legislation passed by the government to punish those who rebelled against the Crown. No compensation was paid at the time to those who were deemed to be rebels. About 1.5 million acres were affected. The Native Land Court was established in 1865 and had the power to adjudicate competing claims to customary land. It was required to name no more than 10 owners, thereby removing land from the ownership of multiple other tribal members. The land was then held individually rather than communally or as trustees, with owners able to sell as they wished. Later, the Native Land Act of 1873 resulted in the ownership of Māori land becoming fragmented, with the court being able to put everyone with an ownership interest rather than just 10 people on the title. And individual Māori effectively received shares and blocks that were then divided up again and again into uneconomic segments, with many subsequently needing to sell their interest to pay for the cost of the process. The Crown and private buyers continue to use unfair and fraudulent methods to gain ownership, such as debt entrapment. In addition, the Crown acquired land for public infrastructure projects under public works legislation that was first passed in 1864. The laws enabled compulsory acquisition, sometimes without compensation, for things like roads and railways, with Māori land targeted and then sometimes not used for the stated purpose. By the early 20th century, only about 7.4% of the land in the North Island and none in the South Island remained in Māori ownership. The amount was further reduced as the century progressed. The alienation of Māori land in the North Island from 1860 to 1939 is shown in these maps from the Te Ara website, the Encyclopedia of New Zealand. As I noted, the land in the South Island was largely owned by the government or private individuals as a result of the sale of vast areas that occurred between 1844 and 1864. From 1849, the major South Island tribe, Ngātahu, started complaining about the terms of the purchases and broken promises on the part of the Crown. This slide lists various laws that resulted in the ability for the government and settlers to acquire Māori land through various means. All of this legislation is available online on the websites noted on this slide. Starting in the 1950s and 60s, the legislation began to focus on protecting Māori land from further alienation and also enabling the development of existing Māori land, but there were ongoing issues. The 1953 Māori Affairs Act was the governing legislation for Māori land for 40 years. Under that act, anyone who could show that such land was not being put to good use could apply to what was later renamed the Māori Land Court to have its vested in trustees. Then from 1967, amendments to the Act enabled compulsory conversion of Māori freehold land with 4 or fewer owners into general land. The amendments led to protests and demonstrations, and work on developing new legislation started in 1974. In 1975, thousands of Māori and their supporters marched on Parliament to protest and bring attention to the continued loss of Māori land. Also in that year, Parliament passed legislation establishing the Waitangi Tribunal, although it was initially only given the power to inquire into breaches of the treaty that occurred after its establishment. This changed in 1985 when amendments to the legislation empowered the tribunal to investigate claims dating back to 1840. The current legislation governing Māori land is the Te Ture Whenua Māori Act 1993, which I'll talk more about soon. Now, ever since they were able to, Māori have resorted to the courts in bringing claims regarding land rights and other matters. I'm just highlighting a few here, but there have been many, many cases regarding both land and resource rights. These are available on the New Zealand Legal Information Institute website. One of the earliest cases was that of Wiparata in 1877, in which the Chief Justice found that the treaty was worthless because Māori were not a nation capable of entering into such treaties, and since the treaty had not been incorporated into domestic law, it was simply a legal nullity. This was subsequently overturned with the Privy Council in London, which was the final court of appeal for New Zealanders until 2003, in 1901, rejecting the argument that there was no Māori customary law and holding that the New Zealand Court of Appeal had jurisdiction over whether land in dispute had in fact been ceded to the Crown. In response, the government passed the Land Titles Protection Act 1902, which limited the ability for Māori to have the government's land purchases investigated through the courts. The 1987 Māori Council case was important as it began the common law development of principles of the Treaty of Waitangi. It followed the first reference to such principles in legislation in the 1986 State-Owned Enterprises Act. This act allowed the transfer of Crown-owned assets and land to newly established state-owned enterprises. In addition to stating that the Crown was not permitted to act in a manner inconsistent with the principles of the treaty, the Act also provided some protection for land that was subject to claims before the Waitangi Tribunal, although only if the claims had been lodged before the Act came into force. The Court of Appeal held that the Crown's transfer of assets did not accord with the principles of the treaty, which it went on to describe, and left it to the government and the Māori Council to work together to determine a mechanism to ensure that assets remained available to settle historical claims. Legislation was subsequently passed in late 1987 that enabled the resumption of transferred assets by the Crown. The final case I'll note is one that led to law changes, huge protests, and several years of debate and controversy. In the Ngāti Apa case, the Court of Appeal held that the Māori Land Court had jurisdiction to determine whether or not areas of the foreshore and seabed were Māori customary land. The Crown had argued that there was a presumption of Crown ownership over these areas, but this was rejected by the court. In response to this decision, the government introduced and Parliament passed the Foreshore and Seabed Act 2004, which overturned the ruling by deeming that title was held by the Crown, but also provided for Māori to apply for guardianship over certain areas. Before the legislation was passed, the Waitangi Tribunal held an urgent inquiry into the policy, with the resulting report being highly critical of the proposals. The Human Rights Commission also stated that the bill was discriminatory against Māori, and a special rapporteur for the UN Committee on the Elimination of Racial Discrimination visited the country and attended various meetings. His final report was critical of the government in several areas, including with respect to the foreshore and seabed issue. Subsequently, in 2011, based on an agreement with the Māori Party in return for its support in Parliament, a different government repealed the 2004 legislation, with a replacement law making the coastal marine area a common space incapable of sale. The current Act allows Māori to bring customary rights claims to the court or directly to the government, and also to seek to establish customary marine title by showing that the area is held in accordance with tikanga Māori and has been exclusively held and occupied since 1840 without substantial interruption. In 2020, the tribunal held that this legislation also breached the treaty. It remains in force, however, and earlier this year, the court issued its first decisions under the Act, recognising protected customary rights in specific coastal marine areas for several Māori groups. Just briefly on the current situation with respect to Māori land, the 1993 Te Ture Whenua Māori Act governs different categories of Māori land, the main one being Māori freehold land, which is about 5% of all land in the country. The Act recognises the importance of land to Māori and seeks to promote its retention. It provides for a variety of trusts with certain restrictions on transferring ownership. The Māori Land Court still exists with the authority to declare the particular status of any land, change general land to Māori freehold land, and to issue 7 orders. Some targeted amendments to the Act were made in 2020 and came into effect earlier this year, including the ability to use a tikanga-based mediation service to resolve disputes between owners and changes aimed at making it easier to use the land for housing. Also, judges will be able to appoint experts in tikanga Māori and whakapapa or genealogy as additional members of the court. Of course, I must also talk about the treaty settlement process that has been operated by successive governments since around 1990. The framework applicable to the negotiations between Māori groups and the Crown is now well established. The settlement process is in addition to the tribunal process, which, as I noted, results in detailed but non-binding reports on breaches of the treaty, including with respect to land. In fact, both the tribunal and settlement processes involve not only land, but also resource rights and other matters. The treaty of settlement process is conducted by a government agency on behalf of the Crown. In 2018, this was restructured and renamed Te Arawhiti, the Office of Māori Crown Relations. While there are still several settlement negotiations currently underway, the changes were intended to recognise and reflect the journey from grievance to partnership, with the office having responsibility for ensuring the implementation of commitments made in treaty settlements, as well as, for example, developing engagement, co-design and partnering principles that ensure government agencies generate optimal solutions across social, environmental, cultural and economic development, and providing strategic leadership and advice on contemporary treaty issues. In terms of the historical settlements area, the settlements are intended to provide redress to claimant groups with breaches of any of the articles of the treaty prior to 1992. The settlements are with large natural groups, being communities with common ancestry, including individual iwi, a group of iwi, and collections of hapu from the same area. Once such a group is established, its representatives chosen and terms of negotiation assigned, Te Arawhiti negotiates with the representatives to reach a final deed of settlement. Once that deed is signed, legislation is developed, introduced and passed that puts the terms of the settlement into law. This can include three kinds of redress: an historical account of the breaches, along with a Crown acknowledgement and apology; cultural redress, such as changing place names, the transfer of land and co-governance arrangements with respect to natural features, such as rivers, lakes and mountains. Finally, the settlement can contain commercial and financial redress, which may be a cash amount and or property. The settlements are full and final under law, so no additional claims can be brought against the Crown for the same grievances. The major settlements included major early settlements included the 1992 Sea Lord deal, which I'll talk more about soon, and settlements with Waikato Tainui in the North Island and Ngāi Tahu in the South Island. The Waikato area was one that had been greatly impacted by the land confiscations of the 1860s. The settlement included land and cash valued at 170 million New Zealand dollars, while the Ngāi Tahu claim related to the methods used in purchasing its lands across much of the South Island. The Waitangi Tribunal issued a report in 1991 finding that the Crown had acted unconscionably in repeated breaches of the Treaty of Waitangi in its land dealings with the tribes and recommended substantial compensation. The deed of settlement signed in 1998 also provided compensation valued at 170 million New Zealand dollars, and it confirmed Ngāi Tahu's ownership of South Island Greenstone or Pounamu, granted certain rights to sites of significance, and provided the iwi a role in managing conservation estate resources. Furthermore, the Crown expressed its profound regret and apologised unreservedly for the suffering and hardship it had caused by not honouring its treaty obligations. One final aspect of the agreement was that Aoraki, Mount Cook, a mountain sacred to Ngāi Tahu, was symbolically returned to the tribe and then gifted back to the nation. Similar returns and gifts have been part of subsequent agreements covering different parts of the country. Since those early major settlements, there have now been more than 80 settlements with a total value of more than $3 billion US dollars. You can view videos of signing ceremonies and also the passage of various legislation online. These involve speeches, including an apology and waiata or songs, haka, and much emotion.
As mentioned earlier, the Sami used the land in Sapmi for hundreds, likely thousands of years when the Swedish king began collecting tax via Bikarla, who traded with the Sami in the 1200s and later directly from the Sami starting in the 1500s. At that time, the issue of land ownership was largely mute, and the area used were largely indirectly regulated through the use of the Sami themselves. Taxation of the Sami was primarily a way to make a claim on the territory at large, and the state foresaw little alternative use of the area. However, as time progressed, the taxation of Sami reindeer herders became more controlled. Records became more detailed, and the state would identify and specify use of land, mountains, fjäll, and lakes as grounds for taxation, recognizing specific areas as Lappskattefjäll, that is Sami tax lands, where one household was typically responsible for specific designated land, which would include a right to use lakes and mountains. The use of this land was then passed down over generations, but could not be sold. The legal status of the Lappskatteland and Lappskattefjäll is still subject to debate today. The Lappskatteland were often recorded in a similar way to early farmer land, but without the distinction whether it was owned by the state or by a taxed person. Meanwhile, the 1751 Lappkodicil, which I mentioned earlier, explicitly in Article 10 recognized that the Sami had used the land since time immemorial. It is unclear whether the Swedish state viewed this land as state land already in the 17th century, but it did not acquire actual title to the land until 1956. The state constructed legal entities to deal with these land rights, first Lappbyar, then Samebyar. Although it is important to point out that they are different legal constructs, for purposes of this webinar and this webinar only, it will be suffice to say that both served as the foundation for reindeer herding in an area as holders of that right. A map of all 51 current samebyar in Sweden can be found online at the Sami Information Center, same.se. The southernmost sameby is Idre sameby and the northernmost is Könkeme. As the number of reindeer in a specific area increased and available land decreased, following an influx of Sami farmers, non-Sami farmers and forest workers to the area, the state decided to move Sami groups, either by coercion or force. In addition, border rules such as the 1919 cross-border treaty or the 1972 cross-border treaty between Norway and Sweden increasingly limited the cross-border movements of reindeers from their winter pastures area in Sweden to their summer pastures in Norway. Cutting off access to Norwegian land was a direct violation of the 1751 Lappkodicil, which stated that Sami had a time immemorial right to move their reindeer. That right was also recognized just this summer by the Norwegian Supreme Court when it found that Norway's and Sweden's attempt to limit Swedish Sami reindeer herders' use of Norwegian land violated this right. Today, the Sami right to land is primarily based on customary use and not ownership. This slide includes several historic laws that have regulated that use. The current legislation in the Reindeer Husbandry Act of 1971, which includes major amendments from 1993. In accordance with this law, the Sami people have an exclusive right and a monopoly on reindeer husbandry in Sweden, and this right is vested in the Sameby. The most recent border treaty of 1972 expired in 2005. On this page, I've also listed ILO 169 and UNDRIP. Although they have not been adopted as Swedish law, their status as customary international law have afforded them a prominent place in Swedish case law, which brings me to the recent court cases. Although Sweden is a civil law country, because the Sami rights to use land has not been adequately or completely addressed in Swedish law, the Supreme Court of Sweden has been instrumental in defining what rights the Sami have, especially in relation to the state. Three cases that address the Sami land and resource rights are Skattefjällsmålet from 1981, Nordmalingsmålet from 2011, and Girjas from last year. One might say that these cases illustrate a development also of the understanding of what the Sami rights are and acknowledgement of their status as an indigenous people. In Skattefjällsmålet from 1981, the Supreme Court found that the state was the owner of the land in dispute, but in dicta found that at least in theory, use of land by Sami and not only cultivation of land could create ownership rights to that land, provided that the use was intense, steady, and is essentially undisturbed by outsiders. The case did not touch upon international law or Sweden's obligations to the Sami because of their status as indigenous to Sweden, but it established the principle that it was possible for certain Sami groups to have acquired ownership through the use of land. In Nordmalingsmålet, as recent in 2011, the Sami reindeer herders' right to use land in relation to third-party landowners, meaning non-state owners, was not based on time immemorial use, but on a customary use, finding that property owners must accept the Sami reindeer herders' presence based on their continuous previous use of the land. In Girjas, decided a year and a half ago, the Supreme Court held that a Sami village, Girjas Sameby, had the exclusive right to confer small game hunting and fishery rights in its designated reindeer herding area. They based the right on time immemorial possession of that right by Girjas Sameby and its ancestors, starting in the prehistoric area and working itself forward in time to present day, finding that in relation to the state, the Sami of the specific area had a continuous and unhindered use of the land, which included a right to hunt and fish. The decision to create a precedent on how time immemorial should be determined and acknowledge that Sami are an indigenous people of the Sápmi area in Sweden, but it did not recognize an automatic right for all Sami villages to confer hunting and fishing rights in their respective areas. Instead, following the decision, each and every village that claims such a right must go to court to have it acknowledged. Girjas is one of the northernmost Sami villages in Sweden, meaning it's one of the Sami villages that was last to see competing interests from the state or non-Sami populations to land or resources. Other areas of Sapmi, such as southern parts of Jämtland, saw a growing agriculture presence already in the 1600s. Another important aspect of the Girjas case is the reduced burden of proof applied by the Supreme Court, which recognized the Sami group's difficulty in proving its historic use in relation to the state, as the Sami village did not possess the same ability historically to document its use as the state did. Therefore, the Supreme Court made reasonable assumptions based on evidence provided concerning other concurrent Sami practices. Another significant feature of this case was how the court relied on ILO 169, despite Sweden not having ratified it. The court concluded that certain articles of ILO 169, Article 8.1 in particular, is customary international law, and as such binding upon the Swedish state, regardless of its ratification status. The court also referenced Article 26 of UNDRIP, which Sweden has signed. Thus, these articles must now be applied in relation to Sami use of land in the future. Also, Norwegian Supreme Court cases has an impact on Swedish Sami reindeer herders, as they limit or acknowledge Sami groups' cross-border movements of their reindeer. For example, in 1968, the Sarowa Sami base right to move reindeer in Norway was recognized based on the historic use in the Altevatnasaken. But the cross-border treaty of 1972 limited that right. The Sami continued to use the land, however, and had to pay fines to the Norwegian state for doing so. Just this summer, the Norwegian Supreme Court recognized that Sarowa Sami had a time immemorial right to certain areas in Norway that could not be limited by the Norwegian law in question. This user right is not an ownership right and has not been tried whether its right could also be accompanied with right to fishing and hunting, but it provides a right for the Sami village to let their reindeer graze in the area in question and the importance of time immemorial use for that evaluation. The case was not unanimous, however, and a dissenting judge specifically noted that the case should have been heard together with Norwegian Sami representatives, as not everyone can have the same right at the same time. Which brings us to the question that has become more and more prevalent, and that is the issue of competing Sami interests in the same area. That is, where you have two groups of Sami making user claims to the same land, both between Swedish Sami groups and between Swedish and Norwegian groups. One such case is the Vapsten case, which is currently relitigated in Sweden. Last year, a district court gave two groups a joint or same right to land in Vapsten, but it was remanded for relitigation on procedural grounds by an appeals court because the parties had not asked for the same right, only an exclusive right in relation to the other group. All these cases will have an impact on the legislative overhaul of the Reindeer Husbandry Act that is currently in its initial stages. Questions of who is a Sami, who may be a member of Sami village, and what rights does a time immemorial right to land mean for other rights connected to the land, such as right to self-governance in the area. Could that include a right to veto certain use of the land in the future? Time will tell.
And now turning to the issue of natural resource rights, the current legislation in New Zealand governing the management and use of natural and physical resources is the Resource Management Act 1991, or RMA. This act has seen various amendments over the past 30 years, and aspects of it are continuously controversial in one way or another. It is largely implemented at the local or regional level, but there are also national policy documents, and appeals from local authority decisions go to the National Environment Court. The RMA contains a number of provisions related to the status and role of Māori as tangata whenua, the protection of customary rights, and the principles of the Treaty of Waitangi. This includes reference to kaitiakitanga, which refers to a form of guardianship with respect to certain areas and features. There are also provisions regarding particular relationships and engagement with iwi, including iwi participation arrangements, iwi planning documents, transfers of power, and joint management agreements. Although there isn't a specific requirement that those applying for a resource consent to consult with iwi, applicants are advised that such consultation in an early stage of the process is considered best practice. Problems can arise during or after the granting of consents in terms of impacting particular areas and values that are significant to tangata whenua. A couple of examples that gained a lot of attention involve claims that taniwha, which some might characterize as a type of mythical beast, but can also be seen as the life force or spirit of an area, would be disturbed by a development. In one case, in the early 2000s, work on a new road was halted while the issues were resolved with the local hapu, with the transport agency subsequently agreeing to divert part of the road. In another, construction of a prison in the north of the country did eventually go ahead, despite a local iwi's objections that a taniwha and the thermal springs would be affected, and the regional council originally refused to grant a resource consent on cultural grounds. Once again, the RMA is currently under review, and it was recently announced that 3 new acts would be drafted to replace the legislation. The government has stated that one objective of the reform is to give proper recognition to the principles of the treaty and provide greater recognition of the Māori worldview and traditional knowledge. This includes a requirement for decision makers to give effect to the principles rather than only taking them into account as required by the RMA. One proposal is for each region to establish committees made up of local and central government representatives plus mana whenua to develop plans regarding resource management for an area. These plans would replace and consolidate the existing 100 or so plans in the country down to about 14. However, multiple interest groups have raised concerns about the approaches proposed. The marine fisheries areas managed outside of the RMA includes various legislation dealing with Māori rights to this resource. This includes legislation implementing the 1992 Sea Law deal, which settled commercial fisheries claims that alleged the Crown had breached treaty fishing rights through a series of actions and the introduction of the Quota Management System, or QMS, in 1986, which removes statutory recognition of Māori customary rights to fishing and fisheries. Part of the settlement involved the government funding a Māori consortium to purchase half of Sea Law, a major fisheries company. The legislation also includes the protection of customary rights, which is done through specific regulations covering different fishing areas. In addition, the parties agreed that 20% of quota for new QMS stock would be allocated to Māori fisheries, and this was reflected in the 2004 Māori Fisheries Act. The 2004 Act also established an entity, Te Ahu Kaimoana, which works to return assets and funds from the settlement to iwi organisations. A further settlement with respect to aquaculture is implemented through different legislation enacted in 2004, which governs the formation of regional agreements with respect to aquaculture in different areas. A settlement trust is responsible for receiving and allocating aquaculture settlements to iwi, with the iwi of a region able to receive 20% of aquaculture space newly created from 2005, and the equivalent of 20% of existing aquaculture space created between 1992 and 2004. Māori also have rights and interests with respect to other natural resources, of course, including freshwater resources and fisheries, forest and forestry, and the conservation or management of native flora and fauna and protected natural areas. There are ongoing discussions in various areas, such as the implementation of new national policy statement and standards on freshwater management, and the Three Waters Reform Program regarding the delivery of drinking water, wastewater, and stormwater services. I could be here all day talking about the issues and approaches, so I won't go into all the details. Although I do want to quickly highlight some interesting developments in the context of recognising and applying Māori concepts in the management of land and resources. A few years ago, there was international interest and commentary regarding legislation that enacted deeds of settlements with 2 iwi groups in which a former national park area in one case and a river in the other were recognised as having their own legal personalities. That is, they are legal entities with all the rights, powers, duties and liabilities of a legal person. The human face of these entities are boards made up of Crown and iwi representatives, which are responsible for the management of the relevant areas and features. Other settlements have provided for unique co-management arrangements for certain features, such as the Waikato and Waipa rivers and volcanoes in Auckland. The implementation of these arrangements has important implications for RMA or its placements decision-making processes, and Te Arawhiti has produced guidelines on natural resources redress and treaty settlements that includes coverage of the matters that must be considered when developing an arrangement to involve iwi and natural resource management, the role of local authorities when arrangements are being negotiated, consistency with existing laws such as the RMA, possible redress and potential funding to support good management of the resources in the future.
As mentioned previously, the early taxation of Sami included the taxation of their use of resources, such as lake for fishing and land for hunting. These rights are typically connected to ownership of land. That is, an owner of a land also owns the natural resources connected to the land. As mentioned before, the state has little has title to most of the land in Sápmi, and Sami villages have not been recognized as owners of the land they use. The Reindeer Husbandry Act provides that reindeer herders be allowed to use land and water for the sustenance of their reindeer. In addition, members of the Sameby have a right to fish and hunt in its area. No other legal right to resources is specified in law. Under international law, Indigenous people have a right to be heard with regards to issues that affect them, including how resources that are connected to their land is used. Currently, Swedish law provides that the authorities inform and consult the relevant Sami groups before initiation of projects that may affect reindeer herding, such as mining, windmills, etc., or relevant areas in Sápmi. Specifically, the Environmental Code, Chapter 3 and 6, and Mining Act, Chapter 3, Articles 5A and 5C, required the authorities to make an environmental impact assessment, including consulting the affecting Sami groups. And Chapter 3, Article 5 of the Environmental Code states that land and water areas that are important for reindeer husbandry or commercial fishing or for aquaculture shall, as far as possible, be protected against measures that may significantly impede the operations of these industries. However, under Swedish law, there is not a requirement that the relevant Sami group or groups consent to the use. Use by the state or another is nevertheless prohibited if it constitutes a severe inconvenience to the reindeer husbandry, avsevärd olägenhet för renskötseln in the area, as specified in the Reindeer Husbandry Act, Article 30. And initiatives have been canceled or altered with reference to their harmful impact of the reindeer husbandry industry. However, far from all projects are canceled with reference to the reindeer husbandry. For example, there is currently an instruction from the Swedish government to start planning a Norrbotniabana, a railway route in northern Sweden that affects the Sameby is protesting against, arguing that it negatively affects the possibility to herd reindeer in their winter herding area. And in 2019, the Supreme Environmental Court, Miljööverdomstolen, chose to sign off on a windmill project in a reindeer herding area because the area had been designated as a national interest for windmill parks by the government, which took precedent over reindeer husbandry interest, as specified in MÖD 2019-5. In 2021, the Environmental Court similarly found that a windmill park could be erected close to reindeer calving areas, but reduced the number of windmills compared to those originally sought. In 2020, the Swedish government proposed legislation in Prop 2020-21-64 that would create a new consultation order for matters that affected the Sami people and require government authorities and municipalities to consult with the Sami representatives on issues that may affect them. The government bill was submitted to Parliament and the Constitutional Committee for review, and the Law Council had no objection to the changes. But the Swedish government rescinded the bill in March 2021 without further explanation. The Sami people's real influence over the land it uses is thus limited, reflecting how for many years the use of land by Sami was not seen as an indigenous right, but a property right based on customary use, similar to a farmer's historic use of land. With the Girjas decision of 2020, the Sami, which defined hunting as a time memorial right of an indigenous population, that it had the right to regulate in relation to third parties, despite legislation to the contrary, may be the stronger it has been since the start of colonization of Sápmi. But Sweden still has not ratified the ILO 169, and only parts of the convention has been recognized as customary international law by Swedish courts. Changes may be coming, however. An overhaul of the Sami regulation, a Sami government report, has been proposed with an end date of 2025, and the Swedish Ministry for Trade and Industry has specifically tasked the Sami Parliament with defining Sami village membership rules by 2022. The larger review, due to 2025, of Sami regulation, which will be conducted by a specific reindeer husbandry commission, will assess in which parts of state-owned land, including lands used year-round and land above so-called Lapland border where reindeer husbandry is permitted, that Sami village has exclusive rights in relation to the state, to lease small game hunting and fishing rights on the basis of time memorial rights. It would also determine whether the exclusive right to lease hunting rights applies only to small game hunting or to all game, suggest how Sami village should be organized henceforth, assess whether a conciliation mechanism should be set up to resolve dispute between Sami villages, landowners, and other usufructuaries of land related to reindeer husbandry rights, modernize the language and clarify the terminology of reindeer husbandry legislation, analyze whether the right to hunting or fishing belongs also to Sami persons who are not members of Sami villages, and if necessary, propose legislation and changes or other measures to ensure that right. Propose amendments to other legislation on reindeer husbandry that may be required. An important part of this overhaul is to make current legislation conform with GIRA's decision and Sweden's international obligation with respect to Indigenous rights, and will likely look at how other countries live up to their international obligations, including New Zealand. The overhaul will explicitly not look at whether Swedish constitution needs to be changed to reflect the status of the Sami people, however. Whether the right of Swedish Sami groups to herd reindeer in Norway may be in the future entail resource rights is also unclear.
This is a list of articles, blog posts, reports, and guides related to Māori rights that have been published on the Law Library's website over the years, the last few years. The 2016 blog post that I've put in bold may be of particular use as it provides a timeline and various links to relevant legislation and cases, some of which I've referred to today. In addition to these, as I mentioned, there are many online resources, including government websites, legislation and case law databases and journals, including the Māori Law Review, as well as multiple books regarding Indigenous rights in New Zealand.
Similar to Kelly's two previous slides, these slides list resources produced by the Law Library connected to the Sami people. As you will notice, in addition to Swedish resources, it also includes resources pertaining to Finnish and Norwegian law. Major court cases can be found on the Swedish Supreme Court website, and current government reports related to the Sami can be found on the government website riksdagen.se. Historic government reports can be found on the Swedish Royal Library website kb.se. Maps of Lappskatteland, taxation lands, can be found at the riksarkivet.se. Additional information about the Sami can also be found on the Sami Information Center website, which is samer.se. So that concludes our presentation, and we will now happy to answer any of your questions. I don't see any in the chat box, however. So because we have a few minutes left, I want to thank you for attending our seminar, and we hope you found it useful. If you have any questions that we did not get to today, please feel free to contact us via the Ask a Librarian feature on the law.gov website. The next Legal Institute webinar is in September with foreign specialists Tariq Ahmed and George Sadek, who will discuss the free speech and the regulation of social media in Egypt and Pakistan. We hope you will join them then.